Mike Harris back with What in the Law podcast, and I'm going to talk a little bit more about those protection orders or restraining orders and how Colorado deals with them. If you go to court for one of those, there's a few considerations that need to go into how the court is going to deal with the case if everybody shows up and the restraining order or protection order is going to be contested. First factor is this a domestic relationship or not? And if it is there a ongoing divorce or custody case where they are going to possibly combine this? The second factor is there an ongoing criminal case? In some jurisdictions, if there is not an ongoing criminal case, they will refer the situation to a mediation where someone is going to sit down and talk to the parties and see if the issues can be resolved before they actually take the case to an actual trial to see if there's going to be that permanent restraining order or protection order. The third thing is, where is your case? Unfortunately, there is not a uniform consistency within Colorado for how these cases have to go. And the procedures as far as do they combine it with a domestic relations case and whether or not they order such mediation that we were talking about is going to vary from county to county. Now, finally, if you are in a situation where there's not going to be a resolution through a domestic relations case or through some sort of mediation, what happens? Basically, it is a trial. You will have a trial to a judge or a magistrate where the person seeking the permanent protection order will have to establish that something happened, which may or may not rise to a criminal offense, but is something that is of enough concern that, secondly, you need a protection order to keep you safe from that harm. This involves testimony. While it could involve documents, the rules of hearsay are supposed to apply. So you can't just introduce a police report and ask the judge to read it. If the police officer has information that one side or the other wants to present, you basically have to subpoena that police officer, bring that person into the court, and ask the officer the questions. These can involve cooperative witnesses in certain cases where people will just show up for you. And in some cases, you're going to have to subpoena or get an order for a witness to show up to court. And when you have that trial, both sides get to ask questions. It's called direct examination for the person who wants the witness to testify, and cross-examination for the opposing party who wants to look for holes or problems or limitations with that testimony. Both sides will get a chance to present witnesses, including themselves, and finally the judge or magistrate will make a decision on what evidence they believe to be true and whether or not that permanent protection or restraining order is needed. So that's a little bit about protection or restraining orders in Colorado. They come up quite a bit, and while a lot of people do handle them on their own, they can be very difficult at times. And if you do need a lawyer, call someone like me. Or if you cannot afford a lawyer, you can see if there is any sort of legal services within your county. So I will see you next time on What in the Law podcast. And if you have any comments, questions, or concerns, please let me know. You can also find me on the internet at MikeHarrisLaw.com. Or you can call me at 719-635-2005. And I'll see you next time.